You were involved in a car accident and now you want to know, what do we have to show to get a verdict in your favor? Hi, I'm Frank Nunez. I'm a California personal injury attorney practicing in the state of California. So you were involved in a car accident. It wasn't your fault. You're contemplating whether you should make a claim or even perhaps make a lawsuit, but you're concerned about what do you have to show in order to prevail in a lawsuit. Well, in California, we use the preponderance of the evidence standard. It's the slightest standard, meaning that more likely than not something is true or not true. For example, more likely than not is it true that the other driver was in fact careless or negligent, or is it more likely than not true the other driver was not in fact careless or negligent? And the scales are very light and they just require the slightest tilt from one side to the other. It's a much lower standard than you're aware of in watching movies on TV involving criminal cases. Those involve a higher level of standard called the beyond a reasonable doubt. In this case, it's simply a preponderance standard. Is it more likely than not true that something did or did not occur? Is it more likely than not true that the driver was negligent? Is it more likely than not true that the harms caused from the accident were related to the other driver's carelessness? These are the types of questions you'll face when you're contemplating whether to bring a claim or even a lawsuit. I want you to pick up the phone and call me because I can answer these questions. You can reach me at 559-436-0850. I'm Frank Nunez, and thanks for watching.